this play together. So I'll do a little dancing up here and try to get you guys all fired up. But before I get started, let me just give a little bit more background about where I come from. First of all, it's great to be back here at IAC. This is a great club. Doug, you're doing a super job continuing. Mary was one of your predecessors, and I've been coming to IAC meetings for
Al also, yes.
Al, yeah.
President Emeritus.
And a great group for a long time. And you guys, to me, represent what's all good about the inventor community, which are actual clubs on the ground. And one of the 3 hats, or maybe 4 hats that I wear these days, is I'm president of the United Inventors Association. All right. And we're national, supposedly the largest national nonprofit dedicated to inventor education. And I'll give you a little bit of background before I get started on that, but we basically are affiliated with 100 clubs, similar to your own across the country, many not as good as yours. And,
you say that to everybody, don't you?
Yeah. This is a really well-run club. You guys do a great job. But there's wonderful clubs in New York City and in San Francisco and Houston. And I do a lot of Skype calls too, which is great. And 2 months ago, I was actually invited to Iceland to speak to the Iceland Society of Inventors, World Society of Inventors in Iceland, which is cool. So we're branching out a little bit to get around. But basically, I'm a huge believer in real clubs on the ground, doing real things, meeting and commuting. There's only so much you can do online, and this is what it's really all about at the end of the day. And the speaker programs that you guys are running, the people you're getting in are terrific, and so as you participate and share ideas and grow together. Love always hearing about it. I don't get up here as often as I'd like to anymore because I'm traveling a lot around the country, but certainly some of these things we share, and I talk about you guys when I go to other clubs around the country, so it's very cool. And what's also very cool is at the United Inventors Association, we, I don't know how much you guys follow, but how many of you get Inventors Digest magazine? A couple of you. You really should get a subscription. It comes out, I think, 6 or 8 times a year now. And really, it's the magazine of record for the inventor industry. And I'm very excited that in 2 weeks, when the July issue comes out, the UIA is going to be featured on the cover. All right. Because we have a whole new team of people involved. Our new executive director, and I can announce it because he just signed the agreement last week, will be a guy named John Calvert. And does anyone ring a bell with that name? Well, you will hear a lot about John. John has worked at the U.S. Patent Office for the last 25 years. Specifically been involved in the entrepreneurs and inventor area. You know the Inventor's Eye, which is the magazine that the USPTO does. If you don't know that, you should check it out. Inventor's Eye, get on their mailing list because they have wonderful articles on inventors and things going on. And John put that magazine together and launched it. Whenever we've had the liaison with the U.S. Patent Office, with the UIA, it's always been with John, and I've known him for a long, long time. So when I heard he was going to retire, I went to him and asked him if he would mind coming on board and being our executive director, which he's agreed to do, but he's first traveling. He retired, we had a retirement party for him last week at the Patent Office, which I go down to pretty regularly, and he's off in Europe for a few weeks, and when he comes back on August 1st, he gets started, which is exciting. And then the second thing is we have a guy named Paul Neiman. Paul Neiman had a company called Market Launchers, and he's pretty much been on the national scene for many years now as a helper of inventors, and he's our director of operations, which means he does website, financials, things behind the scenes now. And then we have a third person, Jessica Delich. I've gotten to know Jessica really well in the last year and a half. She runs our trade show program because at the UIA we sponsor 6 or 7 trade show inventor areas. We do it at the hardware show, the golf show. We do it at Response Expo. We just did one last week at the licensing show where we set up inventor corners. Like for instance at the hardware show we have 100 booths there. And it gives inventors an opportunity to really, get right out there in the industry, show their wares. A lot of them do licensing deals right there. And Jessica's been running those programs. So you're going to see the 3 of them on the cover of Inventors Digest coming out in the next week or 2. And that's our kickoff for the new group. And we're very, very excited about that. We've started to already raise funds around it. And we've got to do more with education. And we have to get more bigger membership. And we have a lot of things that we have to do. And some of it was inspired by what I'm going to talk about tonight. So that's the UIA. Let me just tell you that professionally, thank you for the intro. I also work a lot with inventors. I run what we call an open innovation program for 2 very large companies, or relatively large companies within their fields. In the housewares area, there's a company called Lifetime Brands. They're the largest non-electric housewares company in the U.S., the largest kitchen gadget company in the world. They own brand names like Farberware and a few others of their own, and then they do business under KitchenAid, Cuisinart, and so forth. So when you see all those gadgets and cutlery and so forth out in the marketplace, that's Lifetime Brands. About 80% of the cutlery sold in Walmart is Lifetime Brands cutlery, for instance. They're very big in gadgets, very big in cutlery, so-so in cookware and bakeware. But they're also very big on the tabletop side. They do Mikasa, they own Mikasa, they own Falsgraf, they own Talsilver, and a number of other things. So they're a publicly traded company on NASDAQ, LCUT, and their sales are, they're not huge. They're about a $700 million company with expanding around the world. And basically, until 4 years ago, they had never gone outside the company to license a product, and everything was done internally. They have about 50 internal people that do design and development. So I'd known the chairman for a long time. I'd done a couple products like Misto and SmartSpin and a couple successes. So I knew the chairman of the company from over the years, and we were talking at one of the trade shows, and he said, boy, it'd be nice if you could maybe do what you do for others here at our company. And we set up this program after a lot of talk about it called Open Innovation. And part of what I do is I product scout for them, so I certainly review things and take a look at a lot of stuff. But then I work a lot with the division presidents in the company, the legal team, to set up a friendly environment where we review things on a regular basis. And we do maybe 8 or 10 licensing deals a year from the outside. I've probably done 75 licensing deals in the last 5 years with them, which is really cool. The program's growing, and they're doing really well. So I was down at an event, an open innovation event, speaking about it with my friend Bob Boris a couple of years ago. And lo and behold, there was this whole room of corporate types, and it was interesting, right? Because everybody speaking on open innovation had like a PhD or smarter, except me. I was just sort of a hands-on person to sort of figure this whole thing out. And afterwards, this group of guys came up to me and they said, we're really not interested, in the theory here. We'd really like to know more about how you actually got this program launched in the company. And before you know it, they said they wanted me to come down, and actually Bob visited with me as well, and start this program. And the company's name is Tektronix Industries, not Black & Decker. Black & Decker is not the biggest power tool company anymore, even though we all think of them as that. Tektronix Industries is the biggest power tool manufacturer in the U.S. They're TTI Group. They manufacture Ryobi power tools, Rigid power tools, and Milwaukee. So you're familiar with their brand names, and they're yes?
Is it just power tools?
No, well, yes and no, okay? I work with the power tool division, okay? The company also owns Hoover vacuum cleaners, Oric vacuum cleaners. I don't do anything in the vacuum cleaner area. They also have a lawn and gardens division, which I don't help. But the company is they're a $2 billion division of a $7 billion company. And interestingly enough, I have brought them power tool innovations, but we've signed a number of licensing deals already on non-power tool products. Some of them are accessories, but we've actually done a few non-power tool deals as well. So we're looking for sometimes hardware things. I have a website called powertoolinnovation.com. If you have something in that area, you can certainly run it past me, powertoolinnovation.com. So,
do we need patents?
It's very helpful. Yes, patents and prototypes are helpful. And there's a questionnaire on my site that you'll see. It takes about 10 minutes to fill in. But if you want to ever call me or shoot me an email and ask me a question, I'm happy. I help thousands of people a year just with advice, and just some things are right for them, some things aren't. If it makes sense to go ahead with them, it's cool. So basically, I'm doing the Open Innovation Program now in sort of 95% of all the housewares products I work with are purchased by women, and on the power tool side, it's like 95% are purchased by men, which is kind of cool. Now, I know nothing about power tools. Nothing, okay? I actually got on a plane one day and I had a Rigid shirt on, and the guy sitting next to me was like going on and on about it. I had no idea what he was talking about, because I'm not really very manly when it comes to that type of stuff. I know a lot more about housewares. But the guys I work with are really into power tools, and that's wonderful. And what I'm trying to do is set up an innovation conduit. And I'm doing it with more companies. I'm actually in some discussions with a large company in California to run their program. And this model of, my model in life, I mean, there's a lot of people that help inventors, and love to help inventors, trust me. But my model was I don't charge inventors at all. I never have. And my earlier successes were back-end participatory, where I made money after the product was successful, which is the way I like to do it. But in this case, the money just comes into my mailbox every month in the company, so it's great. And then they pay me a retainer, and they pay me a success fee. So if it works, it's a win-win for everybody. And the cool thing is I get to go out to the inventor community and help people without charging. And you know what? You can always submit things to me, and if they don't go anywhere, there's no loss. You can take it anywhere else. And as people often say, you know, do you mind if I send it to another company? Absolutely not. I mean, we're out looking for things, and we're looking for multiple things. You're looking for multiple things. You should go out and pursue the deal that's best for you. As I say to inventors, always, always, always do what's in your own best interest. Always. Now, if it's something that I think is a great fit for the company, and the company wants to get involved, these are big companies, they're leaders in their field, I will make a pitch to you that you will not be able to refuse. I guarantee you. I've only lost one deal ever, once we get to that point, because the companies are set up to hopefully be inventor friendly. But at the end of the day, you got to do what's right for you.
So you're better than Shark Tank.
Well, better than Shark Tank?
Yeah.
Different, you know. Shark Tank's not real, you know that, right? You know that. It's not real. They give you a deal, the next day
they're gone.
It's like Snapchat. Goes away. Everybody knows what Snapchat is? Goes away. Doesn't exist. And you can't take a screenshot of it. Doesn't work. Anyway, but it's Shark Tank. I guess it's wonderful, you know, and it gives exposure to the whole thing. I've met a lot of people who have gone on Shark Tank, and it's all great. We never supported it from the UIA because we thought it was not real and the contract is rather onerous and so forth. But that doesn't mean anything. What's important is that people go on, get the opportunity, and get the exposure. And at the end of the day, I don't want to get sappy, but I care deeply. And Mary, you know what I'm about to talk about. When you're in this business long enough, you care deeply about people getting that access to market. And it's only wonderful when it works out for people. And that's what at the end of the day. And that's why I give back about 1/3 of my life to the inventor community through what I do. So, anyway, I didn't want to go down that pitch too far, because what I really want to talk about tonight was patent reform, okay? And we have two ladies in this room right here that got this ball rolling in a lot of ways, and reached out to Doug, who contacted me, and so forth. And Lisa and Trish have done a great job, and I'm going to wind you guys in. So I want you to speak up, because I have no idea what I'm going to say tonight. I want you guys to participate in this. But the patent reform, okay? It's a large topic that didn't start yesterday. It started a while ago, and it started hundreds of years ago. And I always like to ask this trick question: who knows? And if you know the answer, don't bark it up. But who was the first commissioner of the Patent Office in the United States? Does anybody know? George Washington. Close. You're close.
Ben Franklin.
Ben Franklin. You're close. You're close. You're close. You're very close.
George Washington.
Thomas Jefferson. But you're close. Okay, you're close. You get the point, though. Thomas Jefferson. Anybody ever hear of him? Okay, he was the first commissioner of the Patent Office. The Patent Office was the second building built in Washington, D.C. after the White House. If you go down, has anybody ever been to the archives in Washington and read the Constitution? It's right there, whatever article, Americans have the right to own a patent. It's right there. You read it, it brings tears to your eyes. You have that right in this country. The patents are deeply, deeply embedded. Abraham Lincoln said that one of the 3 modern wonders of the world is the U.S. patent system. Okay? And that's why when these idiots want to screw with it, it makes me mad, okay? Because this thing goes back as deeply in this country as the right to bear arms, which you may agree with or not agree with, but that goes back deeply in this country. The freedom to practice whatever religion that you want in this country, and the freedom to own a patent and be able to compete in the marketplace. And this thing is really smart people came up with this system. Really, really smart, like Thomas Jefferson. I mean, smart people, okay, right? Okay? So, and it's worked for a long, long time. And we haven't had that much in the way of patent reform since about 1840, when we went to first to invent, until about a couple of years ago when the AIA came in. And that was an interesting thing, because I remember speaking up here at the time, and I spoke around the country, and there was some just different voices involved in that. But I will say this, that whole process of AIA, which went into effect a year ago March, so about 15 months ago, took about 7 years. 7 years to put together. They had an amazing amount of hearings where they brought in all types of experts, to speak on it. Dave Kapos, who ran the patent office, so I got to know extremely well, cared deeply about the issue. And there was a lot of things on the table that had to be reconciled, and a lot of things were negotiated. And you may not be thrilled, or you may be thrilled or may not be thrilled, but I will tell you this, that the process was open. It was, what do they call that when the two parties get together on something? It was collaboration. Yeah, collaborative, or by whatever it is. But they bipartisan, exactly. And there was tremendous support for this bill. In fact, in the first term of President Obama, it was really, and it has nothing to do with him, but it's our country really. It's probably the only legislation that went through Congress that had support from both parties, and both parties took credit for patent reform, and it was wonderful, and that's kind of where the story starts, okay? So we all were, to varying degrees. I talked to Dave Kapos many times about the inventor portion of this, and he was always interested to hear what we had to say and what we thought about things. And other people went down and testified and so forth, and the community was heard along with others and big companies as well. And when this bill passed, I actually went to Washington, and I got to go to the signing, and I actually got to meet President Obama, and it was very cool. I mean, we all felt, so we all went home. It was like the war is over, We all kissed our wives, and we're back to the farm, right? And then what we didn't realize, okay, and now from now on, everything that you're going to hear is from my subjective viewpoint. But what we didn't realize was that some big tech firms based in Northern California, which will remain nameless, but they're called Google and Intel, had other motives, okay? Other motives, okay? That at the end of the day, they don't rely on patents the way you guys do. Now, mind you, Google started with a single patent. Okay, so 25 years ago, no one heard of Google. They started like someone really smart guy in the room, and I'm sure he's smart. First patent, you can go back to it, and you can trace it down. That's how they got started. But now that they're up in the tree fort, they're pulling they want to pull the ladder up, okay? And there is a Northern California group in Silicon Valley, tech firms particularly, but other ones that don't quite believe in the patent system as much, and think that patents are getting in the way, of real communal development and so forth. So we have a philosophical divide in this country, and I've given this a lot of thought, because after all, what is America or one way you can look at it, and there's a lot of ways to look at America, of course, but one is sort of the rights of the community versus the rights of the individual. And these folks are behind a banner that says there should be communal development, and there's a place for that. I'm not saying there isn't, but not necessarily at the expense of the individual. And the patent system is particularly designed to protect individual rights, okay? Specific claims, specific issues, and specific protection. Now, what's happening to these guys, some of the bigger firms, is first of all, there's a wonderful article in today's Wall Street Journal that lays it out. It says, first of all, when they build some of the tech platforms and some of the phones and things there's different parts in there that involve different patents, so they're paying out royalties on different fronts, and it sort of drives the price up and keeps their margins or profit down. So right off the bat, these guys now have a brand, they've now made it, they're all successful, they don't need, necessarily, they would like to just take your patent and not pay you for it, okay? So that's number one. But number two, to the degree that they do have an argument here, there are what they call third-party entities, okay, that come in, and sometimes these are not the patent holder, the inventor themselves, but they are maybe attorneys or groups that buy patents or whatever, and then they go and sue the big companies for reward. And they're claiming this is a $38 billion a year problem for America, where they have to, pay these guys, and this inhibits real growth, real economic growth, and it's a hindrance. Okay. $38 billion, I mean, Google, I don't know what they made, but they probably have $38 billion sitting in the bank right now. I mean, they're pretty powerful and big companies. These companies have a lot of dough. So how big the problem is kind of interesting. They claim that there's 60% more patent infringement cases today than there were like 10 years ago. And basically, the argument is, well, there's a whole lot more patents being filed for today, and there's a whole lot more going on in the tech sector now. And if you really look at it in apples to apples, conversion over a period of time and total patents, the same number of patent cases are coming forward that came through 100 years ago, which is kind of interesting because on our side of this issue, they did a lot of research and so forth. And it turns out, at least the research that we were supplied by the people that did it on our side of this whole fight, was that about 18% of these patent issues involve what they call this patent troll issue. And let me describe to you what they're saying. They're saying these third-party entities are coming in like patent trolls and suing them. They really don't have the goods, but they have to settle with them because it's easier to do that than to litigate the problem. So this is getting in the way. And they came up with this unbelievably brilliant moniker, patent trolls. I mean, is that, whoever came up with patent troll is a smart MFer. He really is, because, or she is. Probably was she that came up with it.
Actually, it was the attorney's daughter.
Was it?
Yes, he was describing what happened, he just jumped up and she came up with it and said, troll.
Brilliant. Brilliant. They actually had a troll dressed up in Washington. They were walking around the office, and you look at these ogres, you know, and you, of course you still have nightmares that they're hiding under your bed and all this. And so immediately we spent half a day trying to think of what we could come up with on the other side to try to balance this, you know. But I was saying, take pictures of Thomas Edison and put him up, and here's a real patent troll, as you guys described. But in any event, that's sort of a marketing effort. But they got behind this marketing effort. They got this moniker. It's beautiful. They've got their issue and they got their stand. And while we were going back from the battle, you know, like Odysseus trying to find our way back to our wives, they were out gearing up for another war. Okay, and a year later, there's been no patent reform since 1840 to whatever we are last year. And now all of a sudden another bill's coming forward. It was shocking when I first heard about it. And what happened was, and this is sort of the insider scoop on this, which is kind of fun. I had no clue this was going on, and I was, because of our relationship with the UIA, with the Patent Office, and some things we're doing nationally, I've been asked to serve on a number of national committees. One was one on pro bono patent attorneys, and one was on a small claims patent court, which are really interesting subjects that someday, if we make a little more progress, I'd love to come back and talk to you about. But the small claims patent court was something that basically it's I've had several meetings down at GW Law School and so forth to put together a program based on a model that they're testing in England now. And you know, in America, a lot of our law is based on English tort law, and so it would be sort of a natural process to be able to bring big parties and small parties together in a capped format so you could get in and out of patent court. Inventors get what they want, which is a royalty, and you move on with it. So I'm at this small claims patent court. We're advancing all this. And we realized that we needed some help in Congress, perhaps, to see if we couldn't get congressional support for a small claims patent court. And I was working with some federal court judges down there, and they suggested that we go to Representative Issa, who's out in California. He's kind of a right side of the aisle guy who's very wealthy, had a bunch of patents on his own. And as we were researching with Rep. Issa how to go about doing it, we found out that he wasn't really the guy. The guy was this guy, Goodlatte. Has anyone ever heard of Representative Goodlatte? He's from Virginia, okay? And he's chairman, you know, the Republicans control the House. He's a Republican, and he's chairman of the House Judiciary Committee, okay? And this was back in August of last year. So we're kind of researching, a couple of us are researching as we're making plans to go down to the Hill and talk to these guys. So we go down and we start to advance, and lo and behold, we just walked into this hornet's. They're putting together this patent reform bill that they said, have you guys heard about this patent reform? It's the first time I'd heard about it. And basically, it was this patent troll bill that was coming through the Republican, and by the way, I don't care whether you're Republican or Democrat, or it doesn't matter. You know, who's that comedian, Black? Louis Black. You know, Republicans suck, Democrats blow. Okay, as soon as you know that, okay, then, you know, you get the whole thing here. So we went down to try to, you know, I mean, it doesn't really matter, but this came through the Republican House, right? Okay, and they had gotten their hands on this bill that was crafted for them, and they had the lobbyists in there from Google and all that, and they basically were saying a couple of things. Number one, they wanted fee reversal for anybody that sued someone for patent infringement, if they lost the case, that the fees would be reversed. And never in U.S. history has there ever been legislation that legislates that, okay? Now, a court has the right to fee reverse, okay? But it's never been built in as automatic, as an automatic thing. It's literally legislated. So that's just off the wall that someone would do that, for starters, okay?
Can you define fee reverse?
Yeah, fee reversal means that if I'm two parties go to court, the loser pays. The loser pays all the fees, the legal fees, for the winner, regardless. Okay, this would be legislated. It wouldn't be the judge thought it was a frivolous case, you know, and decreed it. It would be automatic. The judge would have no other recourse than to do that. Yeah.
Yeah, that's standard procedure in English law.
Right.
Yeah.
Yes.
The idea is, you know, if you're winning a case in court, it shouldn't cost you money to win.
And it's a very good point. The point is, I don't know if you heard it over here, but this has been a long established, deeply established tenet of English law, okay? And in 1788, when the framers of the Constitution put things together before we had our first president of the United States, they actually looked at this. And John Adams argued vigorously about this. And we, from the beginning of our country on, have not had fee reversal because we specifically did it in a different way. And it's wonderful what they've done in England, and England led the way in a lot of law, but it's not America. It's not in here. So this is called tort reform, okay? Now, interestingly enough, Republicans, supposedly, you know, business-minded Republicans, are supposed to be for protection of private property, you know, interested in entrepreneurs and independent growth, individuals and so forth. But they saw this as tort reform because they think a lot of hard-right Republicans, and again, I'm not blaming either side, they're all to blame. They thought that this was a way to get tort reform on the books, a beachhead, so that they could start getting rid of frivolous lawsuits. And they jumped at this. They thought, now the fact that it was just confined to patents, you know, see, I think if they had brought forth a comprehensive tort reform plan for all of America, that would be a different subject. But they were just bringing it forth in the patent arena, and now you're arbitrarily picking out one little arena, and you're not addressing it in others. But Republicans lost total. This is like, you know, I don't know, some total distraction went by, and they got totally locked. Some beautiful woman walked by, and they just ran after it. Okay, they just thought, oh my God, we gotta do whatever we have to do to get this in. So you had Republicans, hard right Republicans, immediately got on board with this. So that was kind of interesting. Now there's a couple other tenets to this as well. The second part was even worse. It's called joinder. Okay, and that means this whole thing that you could, you know, I'm breaking it down for you in layman's terms, and I'm not an attorney, by the way. I had to have this explained to me about 100,000 times before I got it. Not only if you lost, if you're an inventor and you took a case forward and you lost, could you lose? And by the way, when big companies go to court and you lose, you may not have spent a lot, but they may have spent $30 million, okay? And they, you know, with all the discovery issues and so forth, it's not capped. And now you're on the hook for that. And guess what? If you can't foot the bill, then there's joinder. They could go after anybody that invested in your effort or participated in it. That's going to wipe out, in this country, okay, I came from England too, okay, in 1627, my family did, and I love my heritage and my ancestry, but America has always been, and I grew up in Europe, and I love Europe in every way, and I love everywhere around the world. I've lived all around the world. But in America, one of the great things in this country is the meshing of capital with new ideas, and you don't see it anywhere on the planet, and that's why we are kind of who we are in a lot of ways. You get a good idea, you'll find someone to fund it. You put in joinder into this and fee reversal and this threat, and you will wipe out capital. We did a survey of UIA members in the fall, and 70% said they'd either stop inventing or seriously curtail their inventing. So now you're going to strip out, you know, and we had a guy, by the way, when we went down to Washington, which I'll spend a second, who just raised $45 million for a medical product, and I asked him if this bill had passed, would he have gotten, he said we wouldn't have gotten a dime. Okay, so now you're going to start cutting out grassroots innovation and inventors out of the process from going out and raising capital. Okay, so fee reversal, joinder was an absolute killer, and then the third part of this was what they call stay, and let me just say in general, and I'm sure there's attorneys in the room who could get much more specific with it, but it made it very difficult to actually find out who was infringing on you and where and what country and where in the pipeline people came in if they did infringe you, to identify who to go after to begin with. And this all just makes it impossible for inventors to play fairly in the box. So you have a problem, and it's called, this problem that these high-tech firms identified, that you have sort of third-party people going after and sort of are, causing lawsuits and forcing them to pay money that maybe shouldn't have been done, and maybe it went over the edge. And they want to solve this problem, but instead of having a shotgun, or I should say a rifle-focused approach and a specific answer to it, they decided to just have this general, we're just going to generally, do all these things, and we're going to get the hard-right Republicans to sign on to this because they want tort reform, and we can. And by the way, we're giving tons of dough to them. By the way, they give money to both sides. You know that, right? Okay. But we're going to give them a lot of money, so we get this thing on. I compared it to, you have some weeds in your lawn, and so you sprinkle gas and light the whole thing. Okay, you get rid of the lawn along with the weeds. So this is the problem. But they were on such a roll. This Goodlatte bill rolled through Congress in record time. It was unbelievable. We found out about it early in September, and this thing was passed by early December. I mean, these guys get nothing done there. I mean, trust me, I don't mean to mean them too much, but they get nothing done. They don't get any bills passed that they ever have, and they got this thing through the House with overwhelming support, because what happened was the signal came down on the Democrat side, all the way from the top guy, President Obama, that they wanted additional reform. And you say to yourself, well, why would the Democrats want additional reform? Why what's driving that side? Well, first of all, these companies give a lot of money, to these guys, right from the top. And I think President Obama is absolutely enamored with technology, and I think you say Google, you go around the world, when I was in Iceland, they had a party at the embassy, met the ambassador, the featured speaker was the chief creative officer at Google. I mean, you go around the world. Today, Google is the General Motors of today, okay? And I trust me, General Motors, do you guys ever hear of that company? General Motors, okay. And in the 1950s, okay, these guys, okay, I have a good friend of mine in my town. His grandfather was the chairman of General Motors. He played golf with Dwight Eisenhower 5 times a year. I mean, these guys are running the country in a lot of ways. Did we ever get a public transportation system in this country going in the 50s with General? Not a chance. Okay, did we ever get emission standards? Did we ever get? How about the Corvair? Remember that? I mean, these guys. And look, at 40 years later, we're bailing them out, right? Because what happens when there's no competition? I mean, if we didn't have cars that came in from Japan, they'd still be running the show here. It's when companies don't have competition, this is what happens. And by the way, this didn't start in America. There was the British East Africa Tea Company. They got us into India. They got us into Kenya. They got us into all these places because that's how the British did. They first would start doing trade, and then they'd send in the troops, and then they'd start taxing people, and guess what? People needed money to pay the taxes, so they had to work for the British to get British money to pay. But you guys all know all that. This stuff has been happening. Corporate interest has been happening in America for a long time. Now, mind you, I'm fairly conservative on a lot of things, and I'm probably more libertarian, and I don't like a lot of laws. But when there's no safeguards or protections, and these guys come and do what they want, they can run the show. And when they give enough dough, and they're a big successful company, and high tech is what they want, it all gets very glossy and it enamors people. So the word came down from the top. So President Obama put it into his State of the Union address in January, after the Goodlatte bill was passed, overwhelmingly bipartisan support. He said in his January State of the Union, I almost fell off my chair, that we're going to have further patent reform in this country, and it's coming. Now, we just had patent reform. We hadn't even given it a chance to see how it was doing, and they're already got a new bill coming through because Google is not happy. It didn't go far enough. So now this is like the German army going through Russia, okay? I swear to God, I felt physically ill about this stuff. And we started to do some things. We started to speak out against it, but they were so well organized, and they were so on top of this, and we were so taken by surprise that it was just scary how fast the thing was going. We were just bracing for what's going to be the fallout of this. Now, you know, in Congress, the wonderful thing about the United States government is that we have you know, several different chambers, and we have a tripartite government where people have to come together. And in the case of the Congress, we have a House which passed it, and it has to go through the Senate. Now, the idea was, don't worry, when it goes to the Senate, they're more adult-like in the Senate. Okay, they'll study this and so forth. So on it went to the Senate, and inventors, you know, I was joking with these guys that they're like farmers. Inventors are like farmers, you know. They don't want to leave the farm to go take up arms and fight, you know. I mean, they're not. This is just not the battle, and these guys were just rolling through with panzers, you know. So a few of us started to get together and talk about it. We started to speak out, and then these guys came through from grassroots, which was really interesting because they were working in Connecticut specifically on this issue because they had, on a parallel path, I mean, I'm talking from my own state, arrived at the same conclusion, that this bill was bad for America. And what they started to do was focus specifically on Senator Blumenthal, who's on the Senate Judiciary Committee. And so that makes him a powerful player. And by the way, when you want to go to the House or Senate, you need to focus in on certain individuals because they're players in the field. And certainly Senator Blumenthal was a player, and he was here from Connecticut. That actually made me a little bit more popular among my national friends that were against this because they said, oh, you're from Connecticut, you know, you must know Blumenthal and all this, you know, and how you got. So out of the blue, I get a call from Lisa, and she says, how would you like to get involved with this? I guess she'd come and spoken to Doug, and we were sort of doing our little thing, and I said, I feel so sick about this. I would love to coordinate. And we started to work together, these guys up in Connecticut and Hartford, and I started going down to Washington on a regular basis. And what an experience that was, to go down and walk these famous halls and go in. I went into probably 48 senators' offices, mostly Judiciary Committee folks, but with a group of people we got. Does anybody know Louis Foreman? Louis Foreman owns a company called Everyday Edison's. Louis was on the trip. You know Louis?
He presented here. He's spoken to our group.
Yeah, he's written a book, and Louis is a good friend of mine, and he was in on it. We got a guy named Jim Bauer, who was a professor at Caltech, who had a number of patents and some really incredible stuff. We had this guy with the medical devices in Minnesota, and we got sort of and they also had a group in Washington, a small group, a small lobby firm that got together, started to organize sort of, you know, and then there was some really cool people that had, like one guy, he invented Wi-Fi, okay, Wi-Fi, that's pretty cool. He sold his company for like 400 mil, so he came in on his own plane, that was cool. And then he actually met with, you know, Senator Cruz?
Yes.
Okay, he met with Senator Cruz. I said, how did you guys meet? No, not only did he meet with Senator Cruz was coming over to their hotel, so, you know, that's, if you got enough dough in this country, you know, people come over to your hotel. But they were on our side, and we started to see this little group, and we started to work the buildings really in a grassroots way to get this thing done. These guys were up in Connecticut banging on Blumenthal, and started to write some letters, which they penned and I signed, basically, and started to put additional pressure. And I met many times with Sam Simon, who is the counsel for Blumenthal, to try to understand, why are you guys for this bill? Well, they were for the bill because there was a lot of pressure coming down from the top. When your party's in power and the president comes from your party, he's the boss, you know, and so he wanted this. I mean, look, let's face it. There's not a lot of agreement in Washington on anything, and they had success with patent reform, so why not go back to the well and show people we can work together on this? But I kept telling them, hey, the Republicans, they're pulling the wool over your eyes. They want patent. I mean, the trial attorneys, where are they? They got to be against this thing. They're typically, you know, in the Democrat camp. You know, let's get them out here. What about the AAPLA, which is the Patent Lawyer Association? What about the universities again? These guys, basically, most of what universities doing around the country, they're calling patent trolls because universities are funding as a third party a lot of things that are going on. And there are very few universities, I mean, there are no universities that were in favor of this bill, except for one, Stanford University. Stanford University. where the president
Founders of
owns
Google
$100 million in Google stock, okay, because he sits on their board.
A university was a non-practicing entity. Is that the same
Yes.
thing as a patent troll?
Yes.
So then all the universities are patent trolls.
That's correct. That's exactly correct. All universities should be against this bill. All of them except Stanford, where the guy who runs the place has $100 million in Google stock. And he's out, by the way, some of the guy that invented Wi-Fi was a PhD from Stanford, so I got the whole inside story from him. But he's out trying to convince the California school system, actually lobbying on it. I mean, it's just insanity when you start to think about some of this stuff, about where people's, motives come from and all this stuff. It's really scary. But yes, all universities should be against it, and all universities eventually came out. The question was, could we get these people out of their houses armed and on the battlefront before these guys rolled through? Because this was a speed game. This was the quicker it goes. And, Leahy from Vermont is the chair of the Judiciary Committee, and I got to know his chief counsel pretty well, Alex Gibbon, and she was hell-bent on writing these things up, and it was all how quickly we could sort of get in the way, just sort of lie down and get in the way of this advancing machinery, because once they started to slow down, the game kind of changed a little bit. But what happened was people started to come forward, and by the way, some traditional companies, also 3M, General Electric, they were saying, hey, we have large patent portfolios. We're not in the same camp as these guys. We care about this stuff and innovation. So they started to speak out against it. And as more and more people started to speak out against it, it still would have gone through, in my opinion, but I think Google totally overplayed their hand. I'm convinced at the end of the day that they kept putting the pressure up, and when folks like Blumenthal and some of the other senators started trying to compromise and softening up the language, they got pissed, wanted the strong language, and held the line there. And I think that's where it broke down. I think they've been willing to give a little bit. But here's the deal. Google, 3 years ago, 1 lobbyist in Washington. Today, 100 lobbyists. Okay? And my understanding is, by the way, that this is not the real fight they're gearing up for. The real fight is privacy, and that's coming, and that's what they're really getting the offices for. They have now a 50,000 square foot office for their team down there and so forth. But they got the money and the dough. And by the way, the whole lobby thing in Washington is fascinating. It's fascinating because a lot of the lobbyists are writing the bills. These guys wrote the bills because a lot of them are former staffers, and they go in, and these guys, you got to see these Senate offices where they're all running from here to there, the meeting, and they're working on 12 different bills. They rely on the lobbyists to do a lot of the work and a lot of the research. So if your side isn't being represented, they're not hearing it. So when we got in and had these half-hour, 45-minute meetings with some of these staffers and stuff for the first time, they were hearing the other side for the very first time. So we had to mobilize, and basically what happened was more and more they started to think about their roots, what they stood for, and so forth and so on. I think Google started to overplay their hand. And 4 times we went through this process that the bill's going to come forth today, and we just sweated it out because once this bill, there's a guy named Dana Rohrabacher who was, do you guys know Dana at all? Dana Rohrabacher?
I remember you had a great conversation.
Yeah, this guy was the most fascinating guy. First of all, he's a total right-wing nut job, entirely. And there's wonderful people on the right, but this guy's way out there. But anyway, having said that, he also lives in his office. Literally, when I met with him one morning, he had to leave and take a shower downstairs and come back to the office. He was a Reagan speechwriter years ago and everything. But I'll tell you one thing about the guy, whether he agreed with him politically or didn't, he understood everything. He said, this is a power play. This is nothing more than big companies coming in. And once this bill gets on the table and gets passed, you're done. You're not coming back here for 20 years from now. You have to do everything you can to lie down in this and get it stopped, even if they table it for a year, because then you can come back. And that's kind of where we are now, where I'm happy to say that through a lot of, by the way, this whole, what these guys were doing here in Connecticut, there were some other folks like in Minnesota, that was a big state. Al Franken was a big player on this. The other Minnesota senator, she was going for the patent trolls no matter what. We couldn't convince her. But Al Franken was at least, so there was a lot of time spent with him, a lot of time spent with Leahy. I mean, there's certain senators, that were key in this whole process because they're, they have influence on other members in the committee. And we got them 4 times to finally Leahy came out and said, look, we can't come to an agreement on it. We got the Democrats to stick up for their own principles. And at the end of and Cruz actually weighed in. Ted Cruz weighed in from the Republican side saying this is goofy. I think the guys that I knew had a big effect on him. And they tabled the whole thing. So the whole thing is tabled, which means it could come up It won't come up this year. It's done this year. It could come up next year again. I have no doubt that it will. And will it come up as a watered-down version? I don't know. You know, you're starting to see more things. I think more people are rallying now. You see the article in the Wall Street Journal today. You see other schools talking about things. More people are coming out against this. So maybe the momentum's going all right, but I have no doubt that these guys could come back. And let me just tie in one more little conspiracy with all this. The acting director of the U.S. Patent Office today is Michelle Lee. Okay, Michelle Lee comes from Google. Okay, she's a patent attorney at Google. So you know this thing was, and who was the former guy? Dave Kapos. Okay, who was basically ousted. Okay, and Dave went down and testified numerous times against this bill. And they didn't listen to one thing he said. And he was moved out of the way to make way for the Google entry. And by the way, not one single inventor, not one inventor got to go and testify in any of the House or Senate hearings on this. It was all big companies, big companies. I mean, some of them were 3M, asked good questions. I actually know the chief intellectual property counsel at 3M. And he's very, very good friends with a guy that's on our UIA board, so I had plenty of chance to talk to him. Probably spent an hour on the phone talking to him. He was very thoughtful. That was really helpful. It's amazing how these things work behind the scenes. But so they said, but not one single inventor was invited. Unlike whether you agree or not with AIA, where inventors were every step of the way were involved in the process. So the whole thing, we're just thankful. The whole thing made me literally physically ill. I thank you guys for getting me involved. I thank you for telling them to look me up. It gave me an outlet, but I also am very thankful to the other people around the country I got to know in this whole process. The whole experience of going and seeing how your government works is an amazing experience. The battle's not over. We at the UIA, we have to get better. And we're doing it now. The UIA needs 100,000 members, period. End of conversation. We're not close to that now. We've got to go out and get it. We've got to go back. When we go back with a voice to Washington, I mean, we're not a lobby group per se, but we've got to go back with a voice, okay? Number two, one of the guys that was a lobbyist that helped us with a lot of things and set up a lot of the meetings down there actually runs an entrepreneur club with on the Hill with all the staffers. And we're going to work with him this fall to expand that to an entrepreneur and inventors club, so that we can start trying to get, because people don't know enough about, especially young people, they don't really know enough about the process and what's at stake here. And there's pressures coming down in the patent system from these high-tech firms, but there's also other pressures. There's the maker movement, okay? And I don't know how, are you guys familiar with the maker movement? Most of you guys? I mean, it's a phenomenal thing. And I know Dale Dougherty, and I visited him out in California, and he started the whole movement. He coined the term. And I'm going to speak at the Maker Fair down in New York, at the World's Fair in the fall. And I love everything they're doing. But they basically are not big believers in patents, okay? They're more communal, okay? And quirky, okay? I know Ben Kaufman very well, okay? I love Ben. I love his spirit. Very communal. I mean, they're more of a product development. And that's fine. There's a place for communal. But what happens a lot of time in communals is the community, they don't make any money. You know, Putin is the richest guy in the world. He has like 19 homes, you know, and the little guy doesn't have anything. That's what happens when the little guy doesn't have a chance, okay? So I'm a big believer in individual rights and to make sure that we keep this. We've got to fight on behalf of the Patent Office. I just heard today that Michelle Lee's going to go out of the Patent Office, and they're bringing in a guy from Johnson & Johnson to be the new director of the Patent Office. And he's more of a traditionally believes in the patents and stuff. So maybe this is also another shift that is coming back to us. But all I can say, and you're the only group that I've spoken to about this, so it'll be interesting how we get this message out. But if you care about patents and you care about their rights here, it's under assault. And there are people who don't believe in the patent system like you and I do, and we got to be vigilant about protecting those rights, or we're going to lose them. So I don't know. Did that make any sense? Any of that?
Oh, yeah.
I would love to answer questions. You must have a few. Yeah.
I'm glad I came today.
Taking up this cause so sincerely and for sharing this with us. It certainly is a battle. The irony, it seems to me, is that for all of these years, even long before Google, it was always a Mike makes right kind of situation. I remember the story years ago about the guy who invented the intermittent windshield wiper. And that was, I don't know, GM or whoever. It was 3 manufacturers who were using patent essentially, eventually be settled at the age of 60. And then everybody interviewed him at the time, and they said, "Oh, isn't this great? You won $20 million finally. You won, you prevailed." And he said, "Yeah, it's great. I'm 60 now. I got my 20. I could have used that $20 million 20 years ago when I could have plowed it back in and
Well, see, you're right, and this is why I'm doing professional what I do with open innovation, which is in both cases, both companies I worked with the chairman of the companies, down that we would have. I said I wouldn't do it unless we have a philosophy of being fair to inventors. You pay a fair royalty. At the end of the day, just pay a fair royalty. If you pay 2 or 3% or 4, whatever it is that you negotiate, you build it in, you work around it, and everybody's successful. But if you want to inspire future generations of people to grassroots invent in their garages and on their own time and come up with the next Google methodology or the next Apple computer or so forth, then you have to have incentive, because there is no incentive and it always comes down corporately. You lose all that. So it's not even an issue necessarily of what's fair. I mean, fair is whatever, but in the long run, it'll help in innovation and help our place in innovation, and for years to come if the system is set up properly. And that's what, with all due respect, to our mother country, England, and other countries, that's what we've made decisions here that go away from the grain, for specific reasons. And if we want to keep those, we got to fight for them every day. So. Yeah.
No, I was just going to say, I really appreciate your perspective, because for years I've been watching this train wreck going down the road. I started in '85 in IP, and back then, before we had these non-practicing entities, individual inventors didn't stand a chance. You got crushed. And it wasn't until you had these people who were willing to invest and proceed to litigation and help you with your rights that you actually had parity in the patent system, where the big guys and the little guys could compete on the same field. And as soon as that happened, all of these big companies said, "Stop, wait, come on, we've got to change the system. We can't be dealing with these people on equal footing." Because most of the patents that they're complaining about are probably valid patents. And, let the courts decide is what should happen, but instead they're saying, "Oh no, I'm being sued," and it's patent trolls.
Well, it's interesting enough, while all this was going on, a case was coming through the Supreme Court, and the decision got handed down one day when I was on Capitol Hill, and basically it was a patent troll bill, okay, and the court ruled that under certain circumstances, defined, that there could be fee reversal if the judge found cause for that. It was the judge's decision. So they laid out the framework, and as an attorney or whatever, it's very understandable. So I actually paraded into our Senator Blumenthal's office and announced to Sam, "Well, this fight's over now. The court has already decided." "Oh, no, they already had their talking points, in line from the other side about how, we've got to continue on with legislation." That's what told me that it didn't matter what was happening. These guys were on a pile drive on it. But at the end of the day, I will tell you, I worked with enough federal court judges. They were furious about all this legislation, because when you take it out. Now look, I understand the concept of going to the people and getting a vote, in a majority. But this stuff was well beyond that. So we got it. Most judges in America get it, and they do get the value of that. So that's what we need to keep all this.
Well, the other part of it is that it's kind of a multi-pronged approach. I mean, they went to the patent office to change the rules in the patent office. Now they're trying to change the litigation and change the statutes as well. I mean, a lot of what they did at the patent office of the AIA was to make it a lot more difficult for you to get your patent out. I mean, if they oppose you after your patent's granted and you don't have any backers at that point and you can't defend your patent, you're probably going to get crushed. So they'll be able to steal a lot more patents with the system that they have in place now, where they can challenge patents on the way out the door.
Well, there's some...
And then, that wasn't good enough. Now they got to also kick over into the litigation side and make it impossible, really, for people to get any kind of backing.
Yeah, no, and that's what it is. I'll tell you what, when you can push and shove, it's great, but when you separate capital from new ideas, you're done. You're done, okay? You're done. It's over. We won't have anything.
You separate capital from anything.
Yeah.
That's the name of the game, man.
Yeah.
That's what drives everything now in Washington.
Right.
If you separate it from capital, you won.
And it's amazing how, with all due respect, that a lot of the legislators who have legal backgrounds, incredibly smart individuals, don't really understand economics and where growth actually comes from and how to seedling and grow things. So it's so that's something, and if they're taught by the guys that are already, at the top, they can manipulate. It's very fast. The whole thing is fast. Anybody watch House of Cards? House of Cards? House of Cards? No? No. Oh, immediately go home and get Netflix and watch every series. It's the best show on TV. House of Cards, Kevin Spacey. Yeah, there must be more questions. Yes.
What's this thing going around in the air that everybody's changing their names? I mean, you have dropped USA from the name. Trial lawyers don't call themselves trial lawyers anymore. They're known as American.
But the Redskins are still the
Justice.
Redskins. Right? But the Redskins are still the Redskins.
Yeah, but I mean, a cat doesn't become a dog just because you label it dog.
Well, this is America, marketing. It's,
Yeah.
you got to have a good marketing pitch, so I'm not sure. Yes?
Yeah, thank you for taking us inside the politics. I didn't expect that. That was wonderful. Two-part question. Is it in fact possible to write the legislation such that trolling and real inventorship can be distinguished and just balanced right at the start? And secondly, is there any interest in reality to do that?
Really good question. One of the things I learned was that